right, so good afternoon, everyone. Thank you for joining us on this beautiful Friday afternoon for our presentation today. As you all know, it will be on the topic of bail, which is an important topic for everyone here today. We all have to do bail hearings at some point in our careers. So we're very happy that we're very lucky that we have our presenters today, Michelle Johal, and she has a surprise. We have also Senem Oskin. Many of you probably already know who she is. Thank you for being here with us today, Michelle and Senem. Just before we get into the presentation, I just have a few housekeeping points that I wanted to mention. As always, we ask you to remain on mute during the presentation. We're happy to see you all, so keep your videos on unless you're busy and you have something else to do. We understand, but it's always nice to see everyone. This presentation, as you can see, maybe is being recorded. I guess there will be an opportunity for you to review it later on. The way it will work today is Michelle and Senem have already pre-recorded the presentation. It's around 30 minutes. So the first half hour is going to be the video recording of the presentation on bail. And then the last half hour will be for Michelle and Senem to discuss a few points that they didn't have time to go over during the video presentation. And they will, of course, take all your questions about bail. I will be presenting Michelle and Senem, but before that, I wanted to shout out to our sponsor. We do have a sponsor for today's presentation, and it's Gagan Panu. Who was called in 2016 and has been a sole practitioner since. And he mainly works out of the Peel region, and the majority of his work is drink drive, domestics, drugs, and gun matters. He's a true believer when it comes to the charter to its furthest extent. He loves sports and playing or watching sports, and apparently he also has a passion for sneakers. As for our presenters, many of you already know Michelle. Michelle Johal began practicing in criminal law with a highly regarded senior member of the criminal bar in 2005. In 2011, she left the firm to start her own practice. She now has a Peel-based practice and travels throughout the Greater Toronto area representing clients charged with a variety of criminal offenses. Beyond just being a criminal lawyer, Michelle has a passion for legal education as well. She's an instructor at the trial advocacy course at Osgoode Hall Law School. She also
Oh, we seem to have lost Maya, so I'll step in. Hi, everyone. I'm Cassandra DeMello. I am your Women's Vice President. I don't have handy the background about Michelle and our special guest, so I'm going to instead impose on Michelle. Can you tell us whatever it was that Maya was just about to tell us about yourself? Oh, there she is.
Sorry.
Hold on 1 second, everyone.
Yes, sorry for that.
Perfect. You're back on. Go, Maya.
I am okay. I apologize. So she is also an instructor at the trial advocacy course at Osgoode Hall Law School. She acted as an advisor at Ryerson Law Practice Program. Michelle has been a panelist at multiple continuing legal education programs on various criminal-related topics, including the Law Society of Ontario, the CLA, the OBA, and NJI. Our next presenter with Michelle is Senem Oskin, who was called to the bar in Ontario in 2007. And except for a few brief stints in private practice, she has been in Legal Aid Ontario since 2008, and she's been acting as the manager of the Duty Counsel office since 2015. In her time in private practice, Senem had the honor of appearing in every level of court in Canada. Senem has also been a professor at various colleges, mostly in Police Foundations programs since 2014. We're very lucky to have both Michelle and Senem presenting on bail today with us. So we will start the video now, but before we start, actually, I just wanted to mention, it would be nice if you can all stick till the very end, because we would like to have a group photo at the end of this session as a souvenir for today's session. So we're ready now to start with the presentation from Michelle and Senem.
Ladies, welcome to yet another event sponsored by the CLA Women's Committee. The subject of today's criminal law primer is bail. We all know that whether or not a defendant charged with a crime is released or detained before trial is undoubtedly one of the most important decisions in the criminal process. If bail is refused, the impact on detainees, especially during the COVID-19 pandemic, can be profound. Given the importance of this topic, I decided to rope in an expert to talk about best practices. That expert is Senem Ozkan. Senem is the manager of duty counsel operations in Newmarket. She is well known for arguing R versus Tunney before Justice DeLuca. So Senem is going to speak to her about her submissions in Tunney, but before we get there, we're going to go back to basics. Senem is going to talk to us about preparation, negotiating with the Crown, and best practices. Take it away, Senem.
Thanks, Michelle. So good afternoon, everybody. Thanks for having me. I wanted to start by with one caveat. As lawyers, I'm sure we can all appreciate the caveat. And that is, of course, that everything that I say comes from a duty counsel perspective. And the reason I point that out specifically is there is obviously a very different way to approach things if you're duty counsel versus private counsel. You know, if you're duty counsel, you're in a bail court sometimes for the entire day, sometimes for the entire week, and you're potentially doing 2, 3, 4 contested hearings in any given day. Whereas I think that's fairly rare in the private practice world. And of course, the other huge difference is that as duty counsel, you're generally at the same courthouse every single day. So there's more of an opportunity, I think, to try to affect some systemic change. So with that caveat, I'll start by talking about the first steps, the preparation with respect to a bail hearing. And I say that the starting point is always with respect to the bail materials, the Crown materials that you've been provided. Of course, the onus you're going to need to figure out before you make your arguments. It's important, but for me, the preparation that I do, and I think that all the staff lawyers in my office do, is the same regardless of whether it's a Crown onus or a reverse onus. So you start with the synopsis, the criminal record, outstanding charges. And, you know, when you're reading through the synopsis, before you even contemplate what the Crown position on bail is, read the synopsis with a keen defense lawyer eye. We all know that the synopsis is a one-sided sort of editorial that's written by the police, usually the officer in charge of the investigation. And so it doesn't include it doesn't emphasize some of the weaknesses that will come up in the Crown case down the line. So I always say, read the synopsis, take a look to see if there are deficiencies in the Crown case, because of course you're going to use those to argue whether when you're negotiating with the bail vetting Crown or when you're arguing in court, you're going to use those deficiencies in order to convince whoever your audience is to give you what you want. After you've read the synopsis and you've looked at the record, if there is one, and you've looked at the outstanding charges, you should formulate in your own mind what you think the appropriate form of release is. And the reasons why you think, let's say you think it's appropriate to release the client on what we used to know as an undertaking, so a release order without a quantum but with some conditions. Figure out the reasons why you think that that's the appropriate release. that is going to be your foundation of your negotiations with the bail vetting Crown. And if your negotiations don't work and you can't get a consent on the form of release that you think is appropriate, those reasons that you've come up with are going to be the basis of your submissions in bail court. You obviously need to get as much information from your client as possible. So the client interview tends to be very important. And the timing of the client interview might be such that you only have access to your client before you've been able to receive the bail materials. I don't know if this is the case in other jurisdictions, but certainly in Newmarket, there is a significant delay in even our office receiving the bail materials for the new arrests that we have. So we end up doing the interview sometimes hours before we've had a chance to speak to the client. So make sure that you canvass all of these things. Are there potential sureties? Are there mental health issues? Are there addiction issues? Is your client Indigenous? Are there supports in the community that your client might benefit from? And this is all information for you. You're not going to, throw this all at the bail vetting Crown when you're speaking to him or her, but you need to know all of these things, because maybe when you receive the bail materials, you're going to need to make a referral to the mental health workers in your courthouse. Maybe you're going to need to make a referral to a bail program for supervision, and your client certainly needs to be aware of that possibility. So the client interview is really important with respect to all of those areas. After you have done all of that, obviously you need to speak to the Crown. We're going to talk about negotiating with the Crown in the next slide, but you should always keep in mind that after you know for yourself what the appropriate form of the release should be, you should be prepared so that when you get the Crown position, you should be prepared to argue either a focus hearing or a bifurcated hearing, because there are some scenarios where, let's say the Crown is offering a consent to a surety bail. You have decided that it's more appropriate for a release order on your client's own signature. It would be my argument that in that scenario, your client has next to no jeopardy in you running the focus hearing. And in fact, in my own personal experience, in the almost 4 years, I think, that we've been doing these types of hearings, I've never had a client tell me that they will not allow me to run a focus hearing, because essentially you start out by saying to your client, look, you're definitely going to get released, but the Crown wants so-and-so to sign you out. So the Crown wants your mom to sign you out. Your mom is here. Your mom is ready to go. Your mom is prepared to sign you out. But I think it's more appropriate for you to get released on your own signature. And so I would like for you to allow me to do a hearing in order to ask that you get released on your own signature. And like I say, in the over 4 years that we've been doing these hearings, I've never had a client tell me no. And if that is what you end up doing, what you have instructions for, the way that you would start out that hearing, because of course you never know who your audience is, and you never know if your justice is someone who is familiar with focus hearings, bifurcated hearings. So I always start my submissions in that sort of a scenario by saying to the justice, Your Worship, my friend and I are in complete agreement that Mr. X should be released on bail, but the issue that we disagree about is what form that release should take. So we're going to ask Your Worship to determine the appropriate form of release in this case. I'm content for my friend to read in the allegations. Crown Attorney would read in the allegations and whatever materials from the show cause notes, make their submissions likely about why they're asking for surety bail. And then when it's your turn, you simply make your submissions and your pitch for why you think it should be an own signature. And then you have the justice make a decision about the form of the bail. If the justice obviously disagrees with you, then you would have to tender, if this is in case you have a surety, obviously, then you would tender the surety declaration and move on to the to the surety approval process, essentially. So if you're going to end up doing that, obviously you'll have, in addition to having spoken to your client at length and getting all of that pertinent information, you'll also need to have canvassed with proposed potential sureties to make sure that they're aware of their obligations, that they meet all of the criteria, they don't have a criminal record, they're not facing any charges, et cetera, et cetera. And so that if you come to this stage where the justice agrees with the Crown that the Crown has met their onus for a surety, you can then move on and provide all of that information. So that's what I would say are the sort of first steps with respect to preparation. As I said, your next step is negotiating with the Crown. In most jurisdictions, there's a bail vetting Crown. And so that's usually that's the person that you end up doing your negotiations with. As I said, if you are tendering a surety, I tend to be fairly liberal with respect to the issue of bail, and liberal in the sense that I'm of the view that it's a constitutional right that should be limited only in very rare and very narrow circumstances. So usually, I don't start my negotiation with the Crown by tendering, even if I have a surety declaration or surety identification, I usually don't start with that. I will start with my reasons for why I think my client should be released on a known signature. But even for myself, there are a few cases where I have conceded that a surety release might be appropriate. And in those situations, you will need to make sure that you provide all of the documentation that's necessary to the bail vetting Crown. So that'll be the surety declaration if you're going to be using one. Because you can also ask, under the criminal code, you can also ask the court to dispense with its use if your surety takes the stand essentially and gets approved under oath. And in the remote world during the pandemic, you also have to provide, in order for the bail vetting Crown to do a criminal record check for your surety, you also need to provide a picture of their government issued photo identification, as well as a selfie of your surety holding that government issued photo identification. So you would present all of those documents to the Crown, wait for them to check to make sure that there is no criminal record. And if it's a consent release or a focus hearing, you would simply go into court to make that argument. If you can't come to an agreement with the Crown, and the matter is definitely a contested hearing, again, in the remote world, you will need to figure out time estimates for how long the bail hearing will take. Usually that's determining the number of sureties you have, are there interpreters? And I think in most jurisdictions during the remote court process, the contested hearings have to be scheduled through either the trial coordinator or some other stakeholder in the courthouse. So you need to have that time estimate in order to be able to schedule that. And I'll turn it over to Michelle.
Thank you, Senam. So this slide, we're going to talk about R versus Antic. I'm going to touch on Bill C-75, and I'm going to talk about the revised ladder of release. Before I talk about Antic, I want to talk a little bit about what things were like pre-Antic. Senam and I, in the course of our preparations, we had some discussions yesterday, and I told her, this marks my 15th year of practice. And I can tell you that when I started practicing criminal law and running bail hearings, a surety release with onerous conditions quite often was the norm in our bail courts. So it was not uncommon for me to go to court and have a client charged with a domestic related offense with no record, and the Crown would routinely require a surety, and often a residential surety. In Antic, the Supreme Court of Canada raised concerns about the manner in which bail provisions in the criminal code were being applied. In order to facilitate the consistent and fair application of bail provisions, the court offered guidance, and I'm not going to read all of paragraph 67, I'm just going to do my best to summarize it. We all know that section 11E guarantees the right not to be denied bail without just cause, but what's significant is it also guarantees the right to bail on reasonable terms. So save for exceptions, an unconditional release on an undertaking is the default position, not a surety release with onerous conditions. The ladder principle provides that each rung of the ladder must be considered individually and must be rejected before moving to a more restrictive form of release. A release order with sureties is one of the most onerous forms of release. And that's something that we have to take into consideration when we're running bail hearings daily in the trenches. Crowns will often, in a Crown onus situation, ask, what is the plan of release? Who is the surety? Where is the surety declaration? But we need to take a step back and recognize in a Crown onus situation, the onus is not on us, but the Crown to establish why the defendant should not be released on reasonable conditions. So just touching briefly on Bill C-75, that came into effect in 2019, and it was in response to concerns about the impact of detention on Aboriginal defendants and vulnerable populations. The new legislation requires both the police and the judiciary to give particular attention to the circumstances of these defendants.
Next slide that I'm going to talk about is RV Zora. RV Zora is a 2020 decision from the Supreme Court of Canada. I'm going to discuss the facts briefly. In that case, a man in British Columbia was charged with drug offenses. He was released on conditions, which included a curfew and having to answer the door within 5 minutes of a police check. He was charged with failing to comply with his recognizance. In that decision, the court took the opportunity to discuss the restraint principle and the use of conditions that must be tailored to the accused. They established that the bail conditions must A, be necessary, B, reasonable, C, the least onerous, and D, linked to the risks in section 515, sub 10. Again, in this decision, the court confirmed what we had already heard from the Supreme Court in Antic, that the default position is a bail with no conditions. Other conditions, they indicated, could be imposed to the degree that they answer 3 questions. The first question is this person a flight risk? If they are, then a condition that they deposit their passport, I would submit then may be reasonable. 2, will their release pose a risk to public safety? Or 3, is their release likely to result in a loss of confidence in the administration of justice? Zora also confirmed that the use of boilerplate or overbroad conditions that I would submit we regularly see in bail court, or at least we did historically pre-Zora, were not appropriate. Behavioral conditions intended to rehabilitate and conditions directed at the symptoms of mental illness were touched on, and also particularly drug and alcohol abstinence conditions. As a result of this decision, I can say that I've observed a huge shift in bail hearings at the Ontario Court of Justice. Now, it is not uncommon during the course of a bail hearing to see a justice challenge the Crown and ask them to justify each and every condition that they propose in connection with a release. So fortunately, a welcome shift as a result of this decision. I'm going to speak a little bit about the Tunney case and how it came to be. And just very briefly, you know, the road to Tunney was essentially the Antic decision that Michelle's already spoken about came down from the Supreme Court in 2017. And I had naively thought that when that decision came down, even though there was no new law per se that was created by that decision, I'd been hopeful that the way that we did bail court would change given what the Supreme Court of Canada had to say, much like what had happened after the Jordan decision came down. There was almost an immediate change in the way that we did even set date court, let alone, you know, setting trial dates and things of that nature. And Clearly, that didn't happen. There was next to no change after Antic. In fact, in Newmarket, we had a lot of Crown saying, well, it doesn't change anything. We already know this. And so, let's continue with the status quo. And as Michelle alluded to earlier, when I started thinking about bail hearings, and certainly Crown onus bail hearings, it struck me, and this was an argument that I made to Justice DeLuca, it struck me that essentially the Crown, as Michelle said, standing up in a Crown onus hearing at the start of bail court and saying, well, Your Worship, I'd like to hear what the plan is. I'd like to hear from the surety before I formulate a bail position even. It struck me that that was essentially analogous to the Crown at a trial after the defendant entered a not guilty plea, standing up and saying, well, Your Honor, I'm probably going to invite the court to dismiss this case, but I'd just like to have the defendant hit the box first. I just want to ask him a couple of questions. And Justice DeLuca's reaction, as I'm sure most of you will have the same reaction, was, I mean, clearly that can't happen. That would be, ridiculous. And so I use that analogy to say, in this context, in the trial context, any Crown that tried to do that would be laughed out of court. And yet in the bail context, we've allowed this. And when I say we, going back to the idea of, a duty counsel office being better situated in some ways to try to affect systemic change by virtue of being in the same courthouse and all of that. When I say we, I actually mean we. I took to heart the, even though in Antic, the court doesn't necessarily use the culture of complacency terminology that they did in Jordan, it basically struck me that, we were part of the problem, and certainly duty counsel doing a lot of bail hearings in the province of Ontario, it really struck me that we were also part of the problem and that we had to do something about it. And so we basically started informally a bail project in Newmarket. My staff and I had several meetings where we formulated essentially what we would be doing. We didn't call them focused or bifurcated hearings at the time, but we basically said, if it's a Crown onus, we're going to push to make it a true Crown onus. We're going to ask for the position. We're going to ask for a ruling before we even say word one about what our plan might be. And of course, alongside of that, we also had to have a route for remedy if what we said wasn't complied with. And so we also decided that we were going to start to review any cases where we had tried this and we were shut down. And so Tunney was one of those cases. The Tunney hearing in the first instance, I think, fit a lot of the criteria that we had set out in that way. Asking for the defense to call evidence first. There was a suggestion by the court, even though the Crown wasn't seeking detention, there was a suggestion by the court that, if my colleague didn't call the surety to testify, that there might be a detention order, et cetera, et cetera. And so essentially we took we filed the bail review. And what happened was Tunney was heard over 2 days. So on the first day, the Crown, who was not Paul Tate, the Crown ended up consenting to Mr. Tunney's release on his own. So we ended up vacating the old release, the old bail order as it then was, and he was released on his own. And then I sought leave from Justice DeLuca to make arguments with respect to the procedure that had been followed. And Justice DeLuca granted that leave. And so we came back to make those arguments at a later date. And so essentially the main push behind all of this was to push back against the status quo. And Justice DeLuca, my favorite paragraph out of the entire Tunney decision is paragraph 57, right at the end, where he says, "I conclude by recognizing that there is an inherent comfort in doing things as they have been done for years. Change is uncomfortable. However, much like the Jordan decision called for a change to the culture of complacency and delay, the Antic decision signals the need for a change in our bail culture. The message is clear. We need to do things differently." And so for me, that essentially summarizes why we took this on and why we pushed back against it. And The timing at that time was right. There were a few decisions that had come down from the Supreme Court with respect to bail, the John Howard Society paper on reasonable bail, and there was a lot of talk about the idea of bail. And you know, it would be my argument now that the timing continues to be ripe for discussion about bail and what's wrong with the way that we do bail, certainly in Ontario. I would say that in the last 6 years or so, there are 4 blockbuster cases that have come down from the Supreme Court on the issue of bail. Plus we have the C-75 amendments that Michelle referred to earlier. So to me, all of that put together is a signal that we're doing bail incorrectly and something needs to be done about it. And it's not something that the Supreme Court is going to leave alone anytime soon, and nor should they. My advice to any lawyer in my office or any young lawyer starting out that comes to shadow in our office, especially with respect to bail, is always that your starting point when you are considering even the idea of bail in general, your starting point has to be the fact that it is a constitutional right and it's not a privilege. And unfortunately, my personal view is that it's come to be viewed as a privilege over the years and the decades. And it's as a result of that we as defense counsel end up being the ones essentially begging, whether it's a Crown attorney or a justice of the peace or a judge, we essentially end up begging for what should really be our client's constitutional right. And so my advice is to start out each bail hearing as though it was your first. I don't mean that in terms of your advocacy or your skills or your knowledge, but approach it with the same naivete that you would have had at your first bail hearing when you probably spent, the preceding 12 and a half hours reading the criminal code cover to cover, well, certainly section 515, reading all the cases that you could get your hand on, and approach it in a way where you're naive enough to believe that the law on the books is actually the practice that's going to be followed, because it's the only way for you to make those submissions and for you to get the court back to those sorts of starting principles. I've already outlined essentially what the procedure is for a focus hearing. Obviously, there's no magic to it. A focus hearing is a hearing that's focused on whatever the issue is. So, detention is off the table. We're asking for a ruling on the form of the release. We're asking for a ruling on the appropriateness of the condition, whatever it might be, a hearing that's focused on 1 or 2 issues. The bifurcation has to deal with essentially separating out the surety approval process from the decision on the form of release. So where you do a bifurcated hearing, going back to the example I used in the beginning, when you've done a focus hearing on the form of release, and let's say you have lost and the court says, the Crown has met their onus with respect to a surety, and so defense, do you have a surety that you would like to tender? The bifurcation refers to the separating out of those two different hearings, and I'm happy to obviously answer any questions that anybody might have with respect to that. But that's the bifurcated hearing practice and procedure in a nutshell.
The next slide deals with reverse onus and when it's a reverse onus. However, I'm cognizant of time, so I think I'm going to skip over to the next slide, which is contested show cause hearings, the procedure, and talk about that because I think it's a bit more informative. So dealing with contested show cause hearings, obviously, with respect to Crown evidence, typically what you'll see in your average bail hearing is the Crown reading in the synopsis. When the allegations are more serious, it's not uncommon for the Crown to call the officer in charge. In terms of what is admissible evidence, well, we know that there obviously are relaxed rules of admissibility at the bail stage, and it's not uncommon, again, to see a Crown tendering photos, videos, timelines, and viva voce evidence from the officer in charge. What I do want to touch on now is cross-examination of sureties and cross-examination by the Crown. And what I want to do is try to just impart some tips and tricks and just something to be cognizant of or mindful of when speaking to sureties and preparing them in anticipation of cross-examination. Now, in my experience, in more serious matters, it's not uncommon for Crowns to cross-examine and explore gaps that may exist in the plan. They're also going to explore potential gaps in the relationship if the proposed surety is not a family member. Be cognizant if your client has a criminal record for failing to comply, make inquiries as to who was the surety in relation to those convictions, because you don't want it to emerge for the first time in cross-examination. The surety that you are proposing is in fact somebody that was acting as surety when your client was convicted of breaching. So you want to make sure that you've already explored failed efforts at supervising in the past and not have it emerge during the course of the contested hearing. Just in terms of supervision, two things that I suggest you can be mindful of. If there are large gaps in the plan, and quite often there are now, I represent a number of young people often charged with very serious offenses, robberies, firearms, etc. What's often the case I've noticed now is young people are at home studying online, and sometimes their parents don't have the luxury of working from home. They have to work outside of the home. And so clearly there are some big gaps in supervision. What I've suggested in some cases is, I know my clients' parents have home security systems, so try and canvass that in advance. I know that Rogers Home Security does have a feature whereby a surety can determine whether or not somebody is entering the home or leaving the home. In very, very serious cases, you may want to turn your mind to contacting Recovery Science and potentially entertaining the possibility of ankle monitoring. I've had some success in that regard with clients who are what I would describe as serial breachers, and ankle monitoring can often be a powerful deterrent that stops that cycle. However, in the course of my discussions with Senem yesterday, she did point out that don't be afraid that if in the course of cross-examination it does emerge that the surety does not have the ability to supervise the defendant 24/7. There should not be an expectation that they're able to do that. And in fact, it is often an impossibility. As long as they enjoy a good relationship where obviously there is respect, the surety obviously has to put some trust in the defendant, and they have the ability to hold the bail if in fact there is non-compliance. So don't be concerned if there is not the ability to supervise the client 24/7, 7 days a week. And I think that that is our time. Thank you very much for attending this presentation. We will see you live, and we'd be happy to take your questions.
Thank you, Michelle and Senem, for this presentation. I just wanted to ask you, Michelle, if there is anything else that you wanted to cover that wasn't covered in that video presentation that we just saw?
Thank you very much, Maya. There are a few things that I did want to touch on that we did not have an opportunity to talk about in the video. We didn't want to play a video for the entire hour because I thought it would be helpful if we could take questions. But before we do that, I want to talk about a few things. I just wanted to canvass perhaps maybe with a show of hands from the audience. I was going to touch on the COVID-19 bail protocol that is available on the Ontario Court of Justice website. If you are not familiar with it, maybe you could put your hand up and I could just cut and paste it into the chat, and perhaps we could move on to other things. I'm not seeing anyone put their hand up. So I'm going to leave that alone for a moment. I'm going to talk about special bail hearings briefly. So clearly, Senem and I were talking about how defendants have a constitutional right to a bail. They also have a right to a bail in a timely fashion. Now, depending on the jurisdiction where you practice, a special bail hearing, I understand downtown can be accommodated fairly easily. I don't practice downtown very often, but this is what I've been told. Whereas in Brampton, I can tell you that I do spend a lot of time in Peel Region. I can tell you getting a special bail hearing in Brampton has often been a challenge. The last time I scheduled a special bail hearing, I can tell you I had a fairly young client, 19 years of age, charged with serious offenses, firearms related offenses. It was determined that a special bail hearing was required, and that determination, to be candid, was largely made by the Crown. But once we'd made that determination, I was instructed to attend at the trial coordinator's office, this was pre-pandemic, to get a date for the special bail hearing. And I was very surprised to learn that the date that I was offered was almost a month down the road. Obviously, I was very upset and indignant on behalf of the client who had no record, but I was told by the trial coordinator essentially, you know, what do you want me to do? I don't have any earlier dates to provide. So I can tell you that I had to jump through a number of hoops, and ultimately I was able to secure an earlier date than a month down the road. But to be candid, it still was not acceptable or constitutional. And ultimately, while the client was released, he naturally was very upset that he was detained in custody for well over a week before he had his bail hearing. Now, I can tell you that the lack of a timely bail hearing is something that has been challenged recently. And I see that we have Ms. Schickman in the audience. I just want to confirm that she's available to maybe weigh in if she's not.
I am, as long as you're prepared to make an exception and let a little man into this group.
Of course.
My man has a day off, and the little guy's gonna join us.
I'm just looking, I'm gonna put it on speaker view. Oh my goodness. Hello there.
That's little Michael. He, of course, had to wake up literally 30 seconds ago. He's like, I want to come too. Yes, absolutely. Do you want to start now, or?
Yes, and so just briefly, I'll introduce you. So everyone, this is Sonia Schickman. So she argued R versus Simonelli in the Superior Court. It was a case obviously dealing with her client who was not entitled to well, obviously his right to a timely bail hearing was not honored. And Sonia brought an application in the Superior Court on his behalf. There was a fantastic remedy. And I'm going to give her an opportunity to talk about the case because the approach that she took in that case was very unique. And I think that it bears mention. Take it away, Sonia.
Thanks, Michelle. So absolutely, this was a very interesting situation, but one that I was surprised that the Crown proceeded this way. It's a Hells Angels massive project. They come in, 30 people arrested, no special court, except for a court that's literally there to adjourn it. And they offer us bail hearings 3 weeks, 4 weeks down the road. I brought a habeas corpus application. If you guys look at it, there's precedent for that, and I had a bail hearing immediately within 10 days. I then brought a stay application saying that the bail delays are unconstitutional, and the stay was granted. The Simonelli decision has been sort of forwarded far and wide to different jurisdictions, and what it stands for the proposition that special bail hearings that are more than 2-3 days away from the original hearing date are unconstitutional, period, full stop. And the charges that were stayed were firearm charges and severe gang-related charges. So they were serious, they were heard. I can tell you that, Michelle, you mentioned something about the fact that Old City Hall downtown, you can get a special bail hearing very quickly. That must be recent, because as of 6 months ago, I had to wait for, well, I ended up getting consent, but I had to wait for a week or two before I could get a special bail hearing. You can all read, obviously, the Simonelli decision, but what I want to talk about now are the variety of other ways that the Crowns can delay a bail hearing. So the Simonelli, and that we should be on the lookout for and try to oppose in the future. So one of the ways that the Crown, and one of the things the Crown argued in the Simonelli, is that, well, 3-day delay is enough, because the criminal code, if we get a bail hearing within 3 days, that's good enough. It is not. So the criminal code says that the Crown can obtain a 3-day adjournment without the consent of the accused. That's true. However, it's limited to investigative purpose. And the Court of Appeal case that I cite in my Simonelli factum, and I'll just read it in, guys, but I think it's very helpful to cite if the Crown's ever asking for a 3-day adjournment. The decision in the Court of Appeal, Regina and Donnelly, 2016, Ontario ONCA 988 at paragraph 80 says a Crown's request for adjournment pursuant to section 516 is not an absolute right, but rather must be made on a good faith basis and informed by the requirement for a just cause analysis pursuant to section 515. So what I want to sort of emphasize is be very careful. When the Crown doesn't have time, they can try to ask for this 3-day adjournment to buy some a little bit of time. Oppose it. It's unconstitutional unless it's for investigative purposes. It can't be we do not have time. The second way that the Crowns will delay the bail hearing is they'll take a synopsis and say, I have 25 pages to read in, so we need a full day because the allegations are so serious and they're so lengthy. What comes from the Simonelli decision as well is Justice Harris's sort of surprise, and he commented on it. The Crown prepared a 34-page synopsis, which was distilled from the original 94-page synopsis. Well, Harris says the judge who released Mr. Simonelli on bail summarized the facts in 6 paragraphs. If the judge can summarize it in 6 paragraphs, so should the Crown be able to. So when you see the Crown standing up with a 30-page summary, and you know that what it's going to do is going to give them an opportunity to adjourn your bail hearing for 2 weeks and have your sureties come back in the middle of cross-examination, oppose it, and said, Your Worship, this is the decision from Simonelli. This is what Justice Harris said. I urge my friend to not read the 30-page synopsis, but take a moment and summarize it into 4 paragraphs. The third way that I find that the Crowns are using to adjourn bail hearings is the assigned Crown. And that was very much the case in Old City Hall, particularly with respect to the child abuse team. They have these Crowns that it absolutely insists that they should be the one present to do the bail hearing. It's their case. Again, that in law is not a valid reason, but it appears that all trial coordinators and justices of the peace say, well, they're not available. Doesn't matter. Get a different Crown to do it. So the Simonelli decision, I think, makes a real dent in terms of adjourning special bail hearings, but we're far from being done because I don't know if it's a procrastinating nature of ours. I don't know if it's an indignant nature of the Crowns, but there's this desire to delay things. And there's a variety of ways that they can try to do that. And we need to constantly oppose it to not let it get to a point where they just create new reasons for the delay and the end result is the same as it was before the Simonelli. So I see a bunch of questions. I will read them and comment on them, but unless there's anything else, give me 1 second.
Sonia, I'm going to read the one question for you. It is from Gina. She said, Sonia, in your application for the stay, how crucial was it to get affidavits from other lawyers to establish that the delay was systemic? If you were going to bring an application in a similar case in another jurisdiction, how would you establish that the problem is in fact systemic?
So this is, I was very lucky because my client had the funds to do what I needed to do. I've reached out to a number of local councils. Michelle, thank you very much. Michelle gave me a couple of examples in Brampton, but I find that, without criticizing anyone, I find that my partner, Boris Botansky, brought the same application in Zarenchain in Oshawa about 18 years ago. And there was quite a reluctance on behalf of local council to come forward and talk about the very severe systemic issues, particularly because nobody wants to be cross-examined. Nobody wants to point out to examples. So I think it's a real uphill battle. What I think, practically speaking, what you should do in the future is this. What I did was I collected, I basically had a court reporter order random 70 days over the course of a year of bail hearings, listen every time there was a mention of special bail hearings and transcribe it. That's how I created a record. Most of your clients are not going to have that kind of funds, you're not going to have that kind of money. But what I think comes from that, and so what happens is this, after I got my stay, the other council jumped sort of on board and brought the same application for their clients in the same project that was heard a week ago. In response to that application, the Crown called the trial coordinator, who produced an affidavit and relied on these trial coordinator sheets, special bail hearing sheets, to say that the problem is fixed. What do we know from that? I think you guys are now, anybody's now on good footing to subpoena the trial coordinator. I think that if the Crown could have done it in response to the application, then you should be able to subpoena the trial coordinator's records of all special bail hearings. When I try to do it, they took the position in Simonelli, they took the position that they're not bound by any that they're not bound by any of my requests, and that they would vehemently oppose that. I think the application was argued on April 27th and 28th on Project Hobart. So look it up. The Crown called the trial coordinator, who said, look, we fixed the problem over the last month. So if they were able to do that, then it should be open to you to subpoena the same records from the trial coordinator to get evidence of the systemic breach. If the Crown's able to provide, to lead evidence that defeats the claim of systemic breach, you certainly should have access to the very same evidence. So I think, while I was unable to do it and I was sort of running out of time and I had strategic reasons, oh, thank you for spitting all over me. I had strategic reasons why I needed it faster and couldn't wait. I think when you do have the time, absolutely subpoena the trial coordinator. And I mean, listen, we're all a little bit reluctant because God knows you get a trial coordinators on your bad side and you're doing trials in front of Justice Ritchie every day. I get that, but I'm not sure how many. I see some older people recognize who Justice Ritchie is. I too have been practicing for 15 years, and then I think. Anyway, I mean, we got to fight. I mean, there's no other way around. The trial coordinators are very protective of the issues and protective of their own jobs. And it's, I guess, the best way to put it is you got to explain to them it's not personal. It's not you. I'm not going after you. And that's what I kept on saying. I'm going after resources. I'm going after resources. And I try to explain to the trial coordinator, look, if I'm successful, it's easier for you because you get more resources. And that way you don't have to struggle trying to sweat bullets, trying to fill gaps and schedule and overschedule. So reason with them to try to cooperate, and if not, bring a subpoena and use the Project Hobart Crown response as a precedent for the fact that they do have to provide you that information, because clearly they provided it for the Crown and they don't work for the Crown.
Could I just add something very quickly here?
Yes.
Sonia, amazing. He's so cute. Congratulations.
Thank you.
And amazing work on Simonelli. Obviously, I hear that it's had some serious impact with respect to a lot of jurisdictions. The one thing that I wanted to say is, even when it's not categorized as a special, quote unquote, special bail hearing, during this pandemic, I don't know about obviously other jurisdictions beyond Newmarket, but I can tell you that last summer, I personally had a contested bail hearing over a property-related offense that was contested and it had to get scheduled. And the trial coordinator offered me the first available date was 11 days out. Not a special bail hearing in any stretch of the imagination.
Unbelievable.
And the only reason that I point this out is, so I started I started drafting a habeas corpus application, and then the Crown ended up, when I emailed the Crown and said, look, this is what I'm going to do, the Crown ended up saying, yeah, okay, we'll just consent and he can get released. And the next day he was released. The reason that I bring that up is, in this pandemic, everybody is trying to hang on to the status quo, which they've always done, but the pandemic almost gives them sort of, I think, ammunition to try to say, well, it's a pandemic, we have limited resources, and we only have the jail for a certain period of time. You shouldn't accept, I mean, obviously 11 days for any bail hearing is ridiculous. For a property related offense, I think it's egregious. So I just wanted to add that in.
Thank you very much, Senam, and thank you, Sonia, for attending and giving us some background with respect to Simonelli. Just want to answer some of the other questions in the chat. One of the questions was from Cornelia. The question was essentially, what is off limits in terms of questions at the bail hearing? My view is this: generally speaking, asking the defendant about the offense with which they're charged is off limits, but it's up for debate about whether or not Crowns can ask proposed sureties about conversations that they have had with the defendants about the allegation. So generally the approach that I take is I will instruct my client not to speak with the proposed surety about the allegations, just in case that comes up in cross-examination. I don't know what anyone else's view is. Senum, do you object if the Crown asks that question of the proposed surety? Or do you recognize that there's some case law that seems to suggest that they're entitled to ask it, although I will concede it goes both ways?
Yeah, so I think the approach that we've taken in Newmarket is that we try to limit putting a surety on the stand as much as possible. So, and it depends, of course, right? Like Crown onus versus reverse onus. Tunney, everybody argues, only goes so far because it was a Crown onus case. So if you're in a reverse onus situation, which tends to be the majority of bail hearings, unfortunately, they always try to argue that there's no bifurcation and you can't do this. But we still try to avoid a surety taking the stand. And if you avoid the surety taking the stand and get a decision with respect to release and the form of release, and then the Crown tries to start asking questions during the surety approval process, then we would object and say, the surety approval process should really be very restricted to, the areas like, are you able to supervise? You understand what it means. You understand that you can withdraw at any time. You're doing this voluntarily, et cetera, et cetera.
Thank you, Senum. There's one more question, and I think that Senum answered it in the chat. And anyone that has other questions, please feel free to put them in the chat. The question was from C. Purvis. Is the JP seized of the bail hearing in a focus hearing situation? For example, if the Crown agrees to a release, but you want a ruling about whether or not it should be a surety, or I guess presumably their own recognizance, can you put it over to another date to find a surety? Senum's view was that the JP is not seized, and I would share that view. If the matter has to be adjourned, then I would think that another JP could deal with it. Are there any other questions that anyone in the audience has? Okay, we still have a few minutes left, so I'm going to take the opportunity to talk about a little bit about COVID-19 and some of the developments in bail hearings. So one of the most obvious, I think, is we're all trying to, during the pandemic, expedite bail hearings to the extent that it's possible. So I can tell you, earlier in the pandemic, I conducted a bail hearing where my client had maybe 5 sets of outstanding charges and a lengthy record, and an interpreter was required. And reading in the synopsis and the record took half a day, because you may or may not be aware, when they're reading in allegations, the Crown's reading in allegations during the pandemic, and there's an interpreter, the interpretation is not simultaneous, it is consecutive. So I think in response to this, there is a COVID-19 protocol that's available on the Ontario Court's website. I've seen and heard that now bail hearings are being conducted where you simply confirm, I've reviewed the synopsis with my client, I reviewed the synopsis with proposed sureties, we don't need the Crown to read it out. And if that's the case, then we can really expedite bail hearings. And the same goes for the criminal record. And it can simply just be filed. And clearly the Crown can email the synopsis to the justice so they can review it. And so to the extent that it's possible, I'm going to suggest trying to proceed by way of written material to expedite things during the course of the pandemic. One other thing that I'll just urge everyone to be cognizant of, it's an issue that arose this week in the context of a preliminary hearing that I was involved in. At the conclusion of the preliminary hearing, we know that the justice has the authority after committal to vary the bail conditions. But one thing that you need to be cognizant of is the sureties are not required to attend, obviously in person, to sign anything, and the clerk can sign the variation on behalf of the surety. But one thing that you do need to do is you need to alert the surety to the fact that the bail is being varied and get their consent as it relates to the variation because otherwise, if the variation is done without the consent of the surety, it's not even enforceable. And so that's something that was brought to my attention this week by the justice conducting the preliminary hearing. And just, I thought, a helpful tip that I would impart to anybody that's conducting a preliminary hearing and seeking to have their client's bail varied. One of the questions was, is there any case authority for the surety approval process being restricted to supervision and surety declaration? So I'm going to ask C. Purvis to maybe just ask the question out loud, because I'll be candid, I don't quite understand it. So is C. Purvis there?
Yeah, I'm there. You were saying that if it is just a surety approval process, the Crown shouldn't be able to delve into disclosures that the surety may have, that the accused may have made to the potential surety, and you want to restrict that in case they have had a chat. So I'm just wondering what the authority would be to restrict the Crown from doing that. How can you shut them down? Is there any case authority for that?
There is. I can just I can find the site and I can try and put it in the chat. So put it this way, I've seen Crowns try to do it before. I've not objected, but recently I've discovered that there's cases that go sort of in both directions. So perhaps what I could do is I could get the citation after the presentation. And if you could just type your email into the chat, I can get it to you.
And I would just add to that, the surety approval is solely a judicial function. The Crown Attorneys Act indicates that the Crown Attorney can ask some questions with respect to that approval process, but at the end of the day, it should just be with respect to the surety's ability to supervise. So if the Crown Attorney, so you have a ruling, let's say, that this is going to be a surety release, the release itself is done. So now you're just trying to see which body is going to be approved to take on that supervision. And if the Crown starts asking questions about, well, did your son ever tell you that he had stolen this car and he was driving it, and questions related to the offense, I think you can object and say, I'm not sure how this goes to surety approval. And Justice DeLuca and Tunney also refers to this as well.
Thank you, Senam. There was a question from Camara. Can Duty Counsel Oskin share which courthouse in Newmarket does the bail hearings for junior lawyers that wish to observe the proceedings? I think it changes, but is there a particular dedicated court in Newmarket where they have bail hearings every day, Senam?
Sorry, I don't know that I understand the question. Which courthouse in Newmarket? Which courtroom in
Newmarket? I think
it's
the courtroom is dedicated to the bail hearing. So if a junior lawyer wanted to watch, is there a particular courtroom?
Yeah, so during the pandemic, we actually have 3. 100 is the new arrest bail court. 103, also referred to as 302 to muddy things up a little bit, is a contested bail hearing court, solely contested bail hearing court. And 104/303 is essentially a bail remand court. But I was going to say, if anybody has any interest in, shadowing with our office or asking myself or any of my staff any specific questions, I'm happy to provide my email address to everybody, and I can set you up with those shadowing opportunities if you so wish.
Thank you, Senam. So Cassandra just wanted to bring to everyone's attention that I did mention using recovery science. The reason I mentioned it is because obviously I have experience with recovery science, and I can tell you that with the youth that I had who could not comply with a bail order to save his life, the GPS ankle bracelet was the only thing that really stopped the cycle, if you will. And I can tell you that his parents were happy to pay for it in the circumstances, just so they didn't have to attend, bail court every few weeks in relation to a breach allegation or entirely new allegations. Cassandra wanted to point out that Solgen is offering radio frequency and GPS options for free, and it could be available to your client depending on what jail they're being held at. So I'll be honest, I don't know of anyone who's been able to avail themselves of the Solgen ankle bracelet. Is there anyone that's attending today that has?
Oh yeah, can I talk to that?
Yes, please.
Yeah. Oh, yeah. We use it all the time. My office has easily gotten at least 20 people out using Solgen's bracelets. Use the program. CLA fought really, really hard to get Solgen to step up and fund these bracelets. Use the bracelets. And if you don't know what I'm talking about, I've put my email in the chat and I will gladly send you the material so that you can use it and get them started on it. Okay.
So Cassandra, that's fantastic. Could you send it to the CLA women's group as well?
Yeah.
Because so it's what are the criteria or the prerequisites?
Yeah, so there's 4 Toronto-based jails that they're offering the GPS bracelets at. Those bracelets are considered better in law because they can actually see exactly where your client is at any given time. Whereas the radio frequency bracelet, think of it like the TV shows you see where there's like a border or a perimeter around the person's house, and once they've passed that border, then the thing goes off. So radio frequency is also still good because at least you know that they're within the confines of the space provided to them by the program. But it's just not as good as GPS because if they do flee or if they do step outside that perimeter, then you don't know where they are, right? So all you know is that they've breached. So both programs are available at no cost to your client through Solgen. The radio frequency bracelet needs a quick 1-page application signed by a JP. The GPS one does not. Like I said, the GPS one, unfortunately, and this is a frailty or a weakness of Solgen and their program, is that they've only made it available at 4 Toronto-based jails so far. We continue to put the heat on them to get these out to more people and to more jails. In fact, I may or may not have gotten the media to cover this and shame them a bit about this because they had promised us up to 2,000 units, I think, and we're still only at 200. So use the program, it's available. The downfall is that there is sometimes a wait list, but it's there. So send me your emails if you want it, and I'll send you the material so that you are fully informed as to how to access it for your client.
Thank you very much for that, Cassandra. That's really helpful. And I just wanted to say one quick thing about the utility of GPS ankle monitoring technology. In relation to the preliminary hearing that I had referenced earlier that I conducted this week, the co-accused, I can tell you, just shortly before the preliminary hearing was charged with breaching his recognizance, intimidating the witness, having contact with the witness, et cetera, and the witness alleged that the co-accused had attended at a particular location and tried to dissuade him from attending at the preliminary hearing to give evidence. I understand, obviously, the co-accused was arrested. He was brought to the Toronto East Detention Center. He was able to secure bail with the assistance of someone from Kim Schofield's office because the GPS information was able to establish that what the complainant had said was not entirely accurate and that he did not, in fact, go to that location. And so I thought it was helpful that counsel was able to produce a third-party record from Recovery Science showing the GPS coordinates and the data to confirm, you know what, my client did not go to that location on this date at this time. And then as a result, I can advise that the Crown consented to the co-accused bail as a result. So it can be very helpful, I think, at times if your client is subject to GPS ankle monitoring, if it's a situation where there's domestic allegations and there's regular allegations of breach. I know historically I've told clients not a lot you can do except for sort of document, you know, your whereabouts, keep a diary, keep a log, but this is something to turn your mind to. And if it may be available free of charge, it may be able to assist those clients where they can actually then have a defense to the breach allegations. I see a number of other questions.
Yes, and we will be continuing until 2:30, just 15 more minutes. And if ever, maybe Michelle, I know Senem Oskin provided her email. Maybe Michelle, you can also provide your email in case we don't cover all the questions. Maybe you ladies can answer later on.
I'm happy to provide my email. I'm just going to type it into the chat, perhaps at the end of the presentation. So I'm not sure if the messages in the chat are relating to the Solgen, or if there are specific questions, perhaps I'm going to encourage people to ask questions live because there's a number of comments in the chat. Does anyone have any further questions that they wish to ask?
I have a question. So I work as a telephone duty counsel, the Bridges line for people who get arrested. So what would be a way to help duty counsel at the courthouse? Now, normally with COVID, I just tell people that duty counsel will be in touch with them in the morning to get the info for the surety.
Yeah, unfortunately, this is something that Legal Aid has been working on for, it feels like decades. It's probably only the last few years. There's no bridge, no pun intended. There's no bridge between the Bridges line and the duty counsel who are dealing with the matters the next day. So unfortunately, there's nothing that you can do. I can offer you like my email address for anybody that's coming to the Newmarket bail court, because sometimes when you're speaking to an accused person that's being held, they have access to a phone number when they speak to you, and then it's either forgotten or it's, you know, put in their property bag or whatever it might be. Usually we find solutions around that, but right now there's nothing in place to coordinate those efforts. But I appreciate you asking. It would be a pretty big step.
Yeah, I think it would
Anyone
be really
else?
helpful, but I don't think it's even feasible right now on our end. And I don't speak for the company, but you know, it's just one after the other. You just don't have time to follow up. Sometimes we call sureties and just tell them this is what's happening and you should expect a call from duty counsel in the morning.
Yeah, I mean, I think if you have phone numbers for the duty counsel offices and you're actually in contact with the surety, maybe giving that number to them so that at least if we can't get a hold of them for whatever reason, they can call us. But other than that, not much we can do.
Okay, thanks.
Sanem, I have a question. So I know in the presentation you mentioned that the importance of reading the synopsis and paying attention to any bias that's more pro-Crown or pro-police. The problem that happens sometimes in bail hearings is that, or for bails, is we don't always have time to speak enough with clients to get from them their version and what the weaknesses really are in the case. So what do we do when it's not apparent in the synopsis that there are, and there's almost always something weak in the synopsis, but it's really the client who can really tell us about that. But in situations where we don't have a proper opportunity to speak to the client, what should we do?
So I actually think the weaknesses that stand out on the synopsis on their own without you speaking to the client are the ones that are going to take you really far. So for example, if there's an issue with, you know, ID, i.e. you have no idea how, you know, these 12 paragraphs are connected to the person that's in bail court in front of you, your client can provide, you know, further weaknesses, but in my personal opinion, that's something that's reserved for down the line for trial and actual, you know, adjudication on the facts. You know, I think the example that most people will be familiar with is when you read a synopsis that talks about at the end, and, you know, the accused was non-compliant and, you know, had to be subdued, had to be tasered, had to be, you know, there's certain language that suggests to you before you've even laid eyes on the client that your client was beaten by the police, right? Not that that's necessarily a weakness with respect to the Crown case for whatever they've been charged with, but in my opinion, there's a lot of weaknesses that you can explore. And I think, again, my personal opinion is those weaknesses in the synopsis that you can spot without even having spoken to your client are the ones that'll get you further, because you can say to the Crown, I mean, I'm not sure what the evidence of the ID is, because maybe when you speak to your client's going to tell you like, yeah, I tried to run from them and, you know, they caught me, or, you know what I mean? Like your client might tell you something that is going to make it more difficult for you to try to go with your first instinct. That's what I would say.
Thank you.
Thank you, Senam. There was another question in the chat about when it is in fact a reverse onus. I'm going to try and touch on that. So certain CDSA offenses are reverse onus. Certain firearm related offenses are reverse onus. Intimate partner offenses, if there is a prior conviction involving the same complainant, if someone is not ordinarily a resident of Canada, or Section 524 applications. So just be cognizant of those situations. Those are not Crown onus cases, those are reverse onus cases. So I know the time's almost 2:30 now. I'm going to add my email to the chat. I'd be happy to answer any questions that anyone may have had that were not covered during the course of this presentation. So please feel free to email me. Senam's already provided her email in the chat, as has Cassandra with respect to Solgen. And thank you very much for attending. I appreciate that it's 22 degrees outside, at least in the GTA. So I very much appreciate everybody attending today's program. And I wish everyone all the best, and hopefully we'll have an opportunity to see each other in person one day. Thank you very much to Senam Ozgen, who argued Tunny, for coming today and giving us her time. And thank you to Sonia Schickman for attending today's bail primer and talking to us about Simonelli.
And thank you, Michelle, for organizing all of that and for your presentation. And we will ask everyone to just stay for a few more minutes so we can take a group photo.
Thank you for that, Maya.